Thank you and good afternoon. Thanks so much for joining us. It's a pleasure to see you all. And we're very excited. The Federal Bar Association Chicago Chapter's delighted to present the State of the Court address for 2022 for the Northern District of Illinois with Chief Judge Rebecca Pallmeyer. So thank you for joining us. She will review major developments and future plans for the Northern District of Illinois with us today. And before her State of the Court address, I would like to present Eddie Feldman. He is a longtime FBA board member and co-chair of the awards committee, appropriately enough. And Eddie is a partner at Miller, Shackman, Levine, and Feldman. He's presenting our Frank McGarr Award. Thank you.
Thank you, Judge Nagel, and thanks to all coming out on this steamy day to support the Federal Bar Association Chicago Chapter and to participate in the State of the Court address. It's my privilege and honor to announce two recipients of the chapter's Frank J. McGarr Award. This award recognizes distinguished public service, federal public service by an attorney. It's named after one of the great public servants in the history of the Northern District, the Honorable Frank J. McGarr. Judge McGarr was a first assistant U.S. attorney, later ascended to the district court bench, and he served as chief judge of the district court here in Chicago from 1981 to 1986. This year's McGarr honorees are Assistant United States Attorney Craig A. Oswald and the late former Assistant U.S. Attorney and Johnson & Bell partner, Daniel C. Murray. If there's a common theme to these two honorees, it is unsung heroes. Let me talk first and present the award to Craig Oswald. Mr. Oswald has managed the Chicago U.S. Attorney's Office immigration litigation for more than 30 years. He also handles labor cases and supervises about a third of the lawyers in the civil division of the office. He is indeed an unsung hero. His work does not generate a lot of publicity, and he's a good friend to the judges in the district court because he resolves a lot of matters before they get to the court. In nominating Mr. Oswald for this award, the civil chief of the U.S. Attorney's Office, Tom Walsh, had more praise for Mr. Oswald than I can share with you in these brief remarks, but he particularly highlighted Craig's diligence, heart, and compassion. Craig is willing to find creative solutions to the kind of complex civil immigration problems that his office is confronted with. It's also particularly noteworthy that Craig was nominated by one of his opposing counsels on hundreds of immigration matters. That speaks for itself. So it's my pleasure to present this Frank J. McGarr Award to Mr. Craig Oswald, and I have, if Craig can come up. Which has the name of the award and says in recognition of his distinguished, let me try reading that correctly. In recognition of his career of distinguished federal government service, Assistant U.S. Attorney for the Northern District of Illinois, there's also a modest honorarium that comes with this award.
Very much. It's a very nice award. It's a terrific award. I'm limited to 1 minute. So for all my colleagues here that think I'll be funny, I can't be funny in 1 minute. I think that Tom has been a friend of mine, and I've worked with Tom and Linda for 33 years. Those two have worked together for 44 years coming up this fall. So this is a wonderful office. It has given me everything in my professional career and in my personal life. I want to thank all of the assistants who are here, who I've worked with, the people I've supervised, the other, there's a group of superstars in our office that are just terrific. I thank my children, 3 of whom are here today. Even our daughter Faith, who is our extra child, who is expendable, but we love her very much. And I thank my wife, Sheila McNulty, who was our our special assistant immigration person who is the immigration judge, and she is an immigration judge and supervises much of the immigration courts in the country. And it's great to be here with Judge Pallmeyer. Judge Pallmeyer, people are shocked to know that I was a preacher's kid. Judge Pallmeyer, I believe, was a preacher's kid.
Correct.
Lutheran preacher. My dad was a Lutheran preacher. And the first time I ever heard your name, Judge Pallmeyer, was from my Aunt Elsie, who went to Salem and Afton. And she said, tell me about, I just want to tell you about Becky Pallmeyer, who's going to be a judge there. So while people are shocked that I'm a preacher's kid, nobody's shocked that Judge Pallmeyer is. So with that gratuitous sucking up to Judge Pallmeyer. Thank you.
Well, now that we've heard from the son of a preacher man,
Nice.
I'm going to introduce our second awardee honoree, and that's Dan Murray. Dan is the first person ever to receive the award posthumously. Before he passed away in November 2020, Mr. Murray was a retired Johnson & Bell partner who over nearly a 40-year career as a Chicago lawyer developed a reputation for being an expert on federal practice and procedure. Many of those years were spent in the Chicago U.S. Attorney's Office, where he tried some 30 significant cases to verdict and argued appeals, including the first challenge to the constitutionality of the Operation Greylord investigation. Mr. Murray is another unsung hero who over the years showed enormous dedication, not just to doing public service work, but to doing it with excellence and compassion. Mr. Murray's family could not be here today to accept the award, but wanted me to express their sincere thanks for this honor, and the chapter plans to present the award to them personally soon. That concludes the McGarr Award presentation, and at this point, it's my pleasure to introduce the Chief Judge of the Northern District of Illinois, Judge Rebecca Pallmeyer, for our annual State of the Court address. Introducing Judge Pallmeyer after the McGarr presentation is particularly appropriate because of her own long and distinguished career in federal public service. Judge Pallmeyer has served the public on the bench for over 30 years. It's hard to believe, but I checked Wikipedia and that's what it says. First as a magistrate judge and then as a district court judge. In 2019, Judge Pallmeyer made history as the Northern District's first woman chief judge. Soon after that, she's had to skillfully and compassionately lead our district court through the COVID-19 pandemic. I suspect that will be one topic that she will address in her remarks today. So please join me in welcoming Chief Judge Pallmeyer.
Thank you for the introduction, Mr. Feldman, and thanks to our outgoing president, Judge Kim Sue Nagel, who's a real friend of our court and had worked with us on the 200th anniversary celebration just a few years ago. And thank you to all of you who are here today and to the Chicago chapter of the Federal Bar Association. A word about our honorees. It's true that they're unsung heroes, but I have to tell you that there isn't a judge who's practiced, who sat on the bench for any length of time as I have, who doesn't immediately recognize the names of Craig Oswald and Dan Murray and have exactly the reaction that was described here. They're problem solvers. In fact, when Craig Oswald steps in an immigration case, you really feel a sense of relief because it's gonna work out. Either we'll get a really solid brief from the government that makes the decision clear, or we won't, but he's going to be upfront about that and very often get the problem resolved. Dan Murray was a guy who'd come into the courtroom and you would know immediately that he's going to dial the temperature down because he had such an air of calm and decency about him. A man that will be very much missed, not only by his family, but by us, those of us who are on the bench. It's wonderful to see all of you here in person. One of the best parts of returning to more in-person proceedings has been the opportunity to see people in the courthouse and not just from behind a screen. The pandemic continues to present challenges for many of us. You've all heard my comment about the pomp and circumstance of being chief judge. Turns out there's no pomp and a whole lot of circumstance. The whole thing has been a bit like that dream that we all have of showing up for the final exam and realizing that you didn't study and in fact never attended class. The chief judge is not immune from that dream, and neither is the court. But despite the uncertainties and complexities, we have in fact maintained our commitment to the health and safety of attorneys, clients, jurors, courthouse staff, and the visiting public. We've also had the opportunity to engage with the greater community in ways that we never did before, to accomplish the court's mission and to play a wider role in serving the people of the district that we serve as we face this health crisis together. We partnered with local health agencies to provide COVID testing. We held vaccine clinics in the courthouse. We've worked in partnership with local institutions, theaters, universities, and arenas to host naturalization ceremonies. And this pandemic has created real opportunities for us to engage with people and institutions in ways that it hasn't before. I'm looking forward to sharing some details about that in just a few minutes. First, I'd like to update you on a few changes to the bench. So we'll start with those slides. My colleague and friend, Matt Kennelly, took senior status in October 2021. In addition to being a superb jurist, Judge Kennelly masterfully chairs our court's Restart Committee, which is the group that has made a lot of the decisions that affect practice in our building. This is the committee that was appointed in 2022, actually prompted by Judge Kennelly to ensure that we were able to proceed safely throughout the pandemic. Because of his contributions and the committee's efforts, our district has been able to safely continue operations through its layered strategy. Judge Kennelly will continue to carry a full caseload as a senior judge. I also need to boast for a second here. I took that photo. Judge Kennelly's senior status created a vacancy on the district court bench. President Biden nominated Nancy Maldonado for that seat, and on April 25, her nomination was sent to the Senate. Judge Designate Maldonado is with us today, and I'm going to ask her to stand for just a moment. On her confirmation, she will be the first Hispanic woman to serve as a federal district judge in our district. We're also extremely proud of our colleague, District Judge John Z. Lee. John Lee made history in Illinois in 2012 when he became the first Korean American to serve as an Article III judge in Illinois when he became a member of our court. President Biden has nominated him to the United States Court of Appeals for the Seventh Circuit to the seat to be vacated by Judge Diane Wood, who will be assuming senior status. On April 25, 2022, that nomination was sent to the Senate. Both Ms. Maldonado and Judge Lee have been voted out of committee. When confirmed, note, I am not saying if, I don't want to give the people in Washington any ideas. He will again make history, as Judge Lee would be the first Asian American to serve as on our Court of Appeals in the Seventh Circuit. We've also had some losses in our court family. We lost 2 retired judges from our bankruptcy court this year. Judge Jack Schmetterer passed away in December 2021, only few weeks after he retired from the bench. And Judge Irwin Katz, who retired some time ago, passed away in April 2022. Both were longtime dedicated public servants who got their starts in federal public service in the United States Attorney's Office before their appointments to the bench. Judge Schmetterer was a bankruptcy judge for 36 years. He retired at age 91. He was the longest tenured judge in the bankruptcy court's history. Judge Carol Doyle, who served previously as chief judge of the bankruptcy court, has just announced within the last couple of weeks that she too will be retiring effective May 31 of next year, and that will create a vacancy on that bench. The bankruptcy court has faced significant challenges and has adapted in response to the changing needs of litigants before that court. Under the leadership of Chief Judge Ben Goldgar and Bankruptcy Clerk Jeff Alstead, the Bankruptcy Court has amended its local rules in 3 important ways. Amended local rules will permit a hybrid video/in-court motion practice once the pandemic permits motion calls to proceed in the courthouse. Any lawyer will be able to appear either remotely by video or in person or on any motion. Second, the amended local rules now include rules specially tailored to complex Chapter 11 cases. And third, The court has adopted a rule that permits a judge to order any matter to mediation. To that end, the bankruptcy court has set up a new Chapter 13 mortgage modification mediation program. Modeled on similar programs in other courts, the program is meant to help qualified Chapter 13 debtors renegotiate their mortgages and keep their homes. The program is entirely voluntary. It supplies an electronic portal to assist communication between debtors and their lenders. Bankruptcy filings are down. They've continued a 2-year decline that began with the start of the pandemic. Filings nationally fell 16.5% in the period ending in March of 2022. National bankruptcy filings during that year totaled 395,000 compared to about 473,000 the year before. So you can see the decline was significant. Despite that decline, it's important for all of us to know that our bankruptcy court here continues to be the second busiest in the country in sheer number of case filings and has the highest number of cases per judge in the nation in comparison to some by a significant margin. So we're a very busy bankruptcy court even today. Our district court also continues to adapt and adjust and innovate in another year made challenging by COVID-19. Under the leadership of our outstanding clerk of court, Tom Bruton, who's also here, I'm going to ask him to stand as well because I know all of you know that name. Some of you might not know the face, but this is his contributions can't be overstated. He really is a behind the scenes guy who does everything. And I know that because I will tell you that I talk to him several times every day. That's gone on since 2020. And I can still remember an early conversation with him in February of 2020 when he came to my chambers and met with me and said, you know, we're going to have to be worried about this virus. I think we're going to have to be using our emergency plan here and getting that, dusting that off and getting that ready. And I thought, wow, what a panicker this guy is. I seriously thought that. Little did I know. He was way out in front on this, and thank goodness that he was, because we were able to keep going largely because Tom Bruton does everything in the building. We have resumed more in-person operations in recent months. We were able to conduct a total of 69 trials, both bench trials and jury trials, in 2021. Included in that number are 22 civil jury trials in calendar 2021, up 120% from the previous year, and 28 criminal jury trials, up 86% from the previous year. We did have to engage in a second pause in jury trials due to the pandemic, but we resumed jury trials again in April 2021, and we've been holding jury trials ever since without interruption. To do this safely and responsibly, we've adopted a layered strategy that I'll describe very briefly. First, the court screens its jurors by means of a written questionnaire when they're summoned. Gather some information, it saves time during voir dire. To minimize the number of people in the building, we are allowing jury selection for just one trial on any given day. That means that the number of jurors coming to the courtroom at any given time would be limited to about 50, as compared with in pre-pandemic times, we might have as many as 250 potential jurors reporting on a single day. Judges like to start their trials on Monday, we all do. But in order for this to happen, in order for us to be safe, we have to stagger the selection of jurors. And that means when you get your jury trial date, what that means is sometime that week, not necessarily that day. Jurors have, once they're selected, jurors are socially distanced during the trial. We require masks in the courthouses. We have sanitation stations throughout. We've re-engineered our jury boxes to enhance the ability to space jurors. We've installed audio equipment to enable remote sidebars. We've added microphone covers. We've moved podiums in several courtrooms. Jurors do not deliberate in the jury deliberations rooms. They deliberate in a separate full-size courtroom where they can socially distance from one another and spend time during breaks and during deliberations. A third courtroom is used for each trial as well to enable access to the press and observers. And we also provide jurors with individualized participant bags, notebook, pen, sanitizers, wipes. They get free parking, they get lunch. We have had good response from our jurors. Of course, there's some reluctance on the part of some, but in general, people have been willing with these precautions to serve. A very important factor has been testing. We've been engaged in COVID testing. It's a critical part of our strategy, and we've been doing that since February of 2021 when we first began testing all our staff for COVID-19. We use the SHIELD Illinois test. It was developed at the University of Illinois. It's a saliva-based test, so it's non-invasive. Nobody touches you while you're giving your sample, and it's a PCR test, and that means that it's very accurate, very sensitive. It turns out that the virus shows up in your saliva before it shows up in a lot of other places in your body. So it's a really good way for us to catch the virus early and make sure that people, even those who are asymptomatic, are removed from the building. The aim of this program is obviously to protect courthouse employees and visitors by identifying and containing any positive cases. The SHIELD Illinois program for all our jurors, case participants, lawyers, witnesses who will be in the court for more than a day, that all happens on the second floor. And that's where the saliva test is administered. We get results very promptly from that test, not obviously as rapid as the home test that you use at test for antigens, but within typically 24 hours and sometimes as long as 48 hours, but it's very prompt. And the speed and accuracy of the test is really one of the reasons we've been able to stay safe. Potential jurors are tested before they ever even report for voir dire, and then anybody selected to serve on a jury and the case participants are tested twice a week. To date, we've administered more than 26,000 tests, and those strategies have enabled us to pretty safely resume jury trials. At least up to now, we're not seeing evidence of any significant COVID-19 transmission from exposure during a jury trial. I don't lean on that statistic. We never know what might happen tomorrow morning, but at least so far things have gone pretty well. New case filings have been down in our district in calendar 2021, with just 7,378 new case filings, down about 13%. 671 new criminal cases filed, down about 18%. One area in which we did see a notable increase in civil cases has been in our intellectual property calendar. And we're up about 1,000 cases, 14% from the previous year. We have, I think, 12 active MDLs in our district, one very recently assigned to me involving infant formula, not the infant formula shortage that you've all heard about, but another aspect of the infant formula crisis. And those cases present a real challenge for us, but a good one. We appreciate the opportunity to get involved in challenging litigation. I think many of the judges recognize that it's a service that we can provide uniquely here in Chicago, where it's easy to get to Chicago from pretty much anywhere in the nation. And that's one of the reasons that we get a lot of these cases. Another reason is that our court does have a significant history of handling complex litigation, and that's what this kind of work often turns out to be. Let me comment on a significant rules change that we adopted earlier this year in the district court. I've gotten questions about this, and I agree with you, it's very complicated. Parties to a case must now disclose their affiliates, defined as any entity or individual owning, directly or indirectly, through ownership of one or more entities, 5% or more of a party. A party needs to file the statement with its first appearance, its first pleading, petition, motion, whatever. This new process bolsters the court's conflict checking measures and helps us avoid the inadvertent violation of ethical rules on this issue. Some of you probably saw some coverage of this earlier in the year. It's really a challenging issue, even situations where it's unimaginable that the judge's impartiality could be affected, fall within a category of cases where we really do need to recuse. And the requirement that we're imposing on you right now, which I know is onerous, would be helpful to us in ensuring that we don't violate those rules. Technological change in our district has also helped us improve operations. We have implemented procedures to secure highly sensitive documents in response to widespread breaches of confidentiality in the private and public sectors. In May, our court migrated to the next-gen CMECF program, which now allows filers a single sign-on with a PACER account for any court throughout the nation that uses NextGen. The changes in the program itself are not earth-shaking with respect to your user perspective. Apart from this, the biggest challenge for you is that every lawyer, not just every firm, but every lawyer will need to have an individual PACER account in order to file and view documents in the docket. Another key technological initiative is an upgrade to our AV equipment in our Western Division, the Rockford Jury Assembly Room. And our court system department implemented a new electronic scheduling system, which I think is great. It enables members of the criminal defense bar to schedule virtual appointments using a screen, obviously, often just a tablet, to communicate with clients in the MCC, in the Metropolitan Correctional Center. We've also provided internet access at our expense and the iPads themselves to correctional institutions to enable detained individuals to participate, well, to communicate with lawyers and also to participate in hearings remotely. Currently, our systems department is in the process of upgrading audio equipment in 12 courtrooms, and we'll expand that as finances permit. Perhaps one of the most labor-intensive and unsung aspects of the court's technology efforts work was setting up and managing audio equipment for naturalization ceremonies held outdoors in the Quincy Court on the east side of our courthouse. While other districts suspended these ceremonies, we were able to safely conduct citizenship ceremonies outside and socially distanced throughout much of the pandemic, often hosting multiple ceremonies in a single day because of the dedication of our systems team who set up and then disassemble the audio equipment each day. Obviously, you can't be outside during cold weather months, and we've been conducting ceremonies inside the courthouse as well, not in a courtroom. For reasons I've already described, the need for all these courtrooms for jury trials, we don't have a lot of available courtroom space. But again, thanks to our clerk there, we found space, a conference room that actually is assigned to the bankruptcy court that we've been able to use for our ceremonies. But what you're looking at right now is a slide that shows some good news here that goes on in our court. Throughout the calendar year 2021, we administered 630 naturalization ceremonies for nearly 25,000 new citizens. I just can't share with you enough what it's like to conduct one of those ceremonies and see the faces. First of all, the faces of people from all over the world. There's this sense that I think we all have that our immigrants come from south of the border, and that's where they're all from. That isn't true. They come from all over the world. And to see their faces and their clothing and their hairdos and their families and the joy on their faces as they join us in this experiment in democracy, this nation with all its warts, as they step forward and say they want to be part of us, it gives you a sense of hope about what we're doing here and what the future might hold for us. We had 11 ceremonies at special venues throughout the district with the support and goodwill of a number of civic institutions. We hosted ceremonies at Kentigny Park, at Northwestern University's Welsh Ryan Arena. You'll see in one of those photos, you see I wore purple. Yeah, those of you who know Northwestern know you got to wear purple. The United Center, the Chicago Botanic Garden, Theater, Rockford Performing Arts Center, Rockford University, Veterans Memorial Hall, and several ceremonies at the Great Lakes Naval Station in the last year. One of the things that happens with persons who are not yet citizens and enlist in the armed forces is that they are entitled to seek citizenship, and many do. I will have the pleasure of conducting one of those ceremonies tomorrow, and I'm looking forward to it there again to see. These are, often very young people. They're 18, 19, 20-year-old people who are joining us as citizens of the United States. And it's a very happy occasion to be part of that. We've had Illinois Governor J.B. Pritzker and members of our congressional delegation with us at these beautiful and historic venues. And these partnerships are of great benefit to the court. They allow us to administer the oath to a larger ceremony than we could possibly accommodate at the courthouse. It's often more convenient for the participants themselves. And it gives us an opportunity to communicate to the city and the state some of the positive things that go on in the federal court. Let me boast a little bit about our pretrial services and probation offices. They both play important roles in maintaining safety in our community and bring long-term positive change to persons under supervision. Our pretrial services office, under the excellent leadership of Chief Amanda Garcia, she's with us. I wonder if you would stand up and wave. Chief Garcia. There was a decrease in new bail activations from fiscal year 2020 with 855 new activations, and the number of cases received for supervision decreased. But I think that gave the pretrial services office the opportunity to engage in some really good initiatives. Under the Second Chance Act, the office has provided emergency transportation services, food cards, clothing, and hygiene items to clients. They also continued the critical work of our district's SOAR program, SOAR, standing for Sentencing Options That Achieve Results. It's a collaborative court committed to providing an alternative to incarceration through a creative blend of treatment, sanctions, and incentives to effectively address adverse behavior. The SOAR program, I think we've got another slide for that, was established in 2016, and it's an 18 to 24-month program designed to help participants address the underlying causes of their criminal conduct by providing a variety of programming and treatment services. Participants attend regularly scheduled court sessions with other program participants, 2 SOAR court judges, 2 assistant United States attorneys, 2 federal defender program staff attorneys, and the supervising pretrial services officer. Participants who successfully complete the program receive one of 3 possible outcomes. The charges may be dismissed, the charges may be reduced to a misdemeanor, or there may be a felony adjudication that does not require a custody sentence. We had 9 new participants join us in that program in 2021, and they're going to graduate early next year, 2023. In February of 2022, this year, the SOAR program graduated its 3rd class, which included 7 participants. I want to thank Judge Amy St. Eve, now our Court of Appeals, who in March 2022 she continued with us as a SOAR court judge, but stepped down as of March 2022. Want to thank also Mary Rowland, who's with us today. She also served on the SOAR court since the beginning, and Judge Beth Jantz, who's been with the program in November 2021. Is Beth here? I'm not sure I see her. But Mary, if you'd stand up and wave. Okay, great. Now to our probation office, under the exceptional leadership of Marcus Holmes. There he is, Chief Holmes. If you could say hello, good. 6 pre-sentence referrals in fiscal 2021 and 2,100 persons under supervision at the end of the year. The probation office also has a restorative justice program, the Second Chance Act. And under the Second Chance Act, the probation office has assisted its clients with emergency and transitional services such as housing at local motels, enrollment in driver's license schools, barber schools. In 2021, the probation office began a Nurturing Fathers program for clients. This is an evidence-based course designed to teach parenting and nurturing skills to men with a focus on healthy family relationships and child development. A personal comment here, I'm such a supporter of this. I think those of us who are women know that often it's women who are viewed as primary caregivers and expected to do work that anybody ought to be able to do. And I think until men shoulder their burden in that regard and recognize the need that their children have for them, women will not be equal. So I thank you, Chief Holmes, for putting that program in place. Another program from our probation office offers to benefit persons under supervision is the James B. Moran Second Chance Reentry Court Program. Judge Moran was, of course, Chief Judge years ago. We named the program for him. It offers a creative blend of treatment and sanction alternatives to effectively address participants' behavior and rehabilitation, as well as the safety of our communities, with an emphasis on sustained sobriety, gainful employment, and other pro-social activities. Participants are expected to meet high standards of participation, higher than traditional supervision, and they receive hands-on support and opportunities to transform their reentry experience and end supervision early. Many thanks to the judges who participated in that program would be Judge Sarah Ellis, Judge Sharon Coleman, Judge Susan Cox, and Judge David Weissman, who volunteered their time to participate in the program. But there are many other participants as well, including the probation officers themselves, United States Attorney's Office representatives, and persons from the Federal Defender Program. We currently have 17 participants, 11 of them graduated in 2021. The Union League Club hosted that ceremony, and Mayor Lori Lightfoot was the keynote speaker in a very moving ceremony that afternoon. The Second Chance program also arranged for a pop-up vaccine clinic outside the graduation ceremony. So graduates and their families, some of them reluctant, had an opportunity to get the shot, which was great. We are extremely grateful to the institutions in our district, the Union League Club, the sports arenas, Welsh Ryan Arena, all of these places that have opened their doors to us for ceremonies like this one and the naturalization ceremonies held throughout the pandemic. We know that we have a responsibility to help those people in our district during the current public health challenges. As a result, we have hosted some clinics and we've encouraged jurors, attorneys, individuals attending naturalization ceremonies to get vaccinated. I, as you know, many of you know, send a letter out whenever we hear of a positive test of anybody in the building. The letters are far too frequent. I don't really enjoy writing them, and I know that you people don't enjoy reading them, but one of the things I do is try to give you a little pep talk, and I often mention vaccines. I'm sure you're probably tired of hearing about it, but it could not be a more important way to contribute to the ending of this scourge. In December 2021, we offered a community pop-up booster clinic. We had offered a vaccine clinic during the summer. We offered a booster clinic in the fall, in December 2021. And in December 21, we gave more than 1,200 vaccines to members of the public in our building. We have also responded to the need for access to free, fast, and convenient COVID-19 testing in the loop. I already mentioned the COVID-19 testing we do for our trial participants. In addition, because that partnership with Shield, Illinois was so successful, we were chosen as a site for the Chicago Department of Public Health's clinic. And beginning in January, we've been offering COVID-19 testing in the lobby of the Dirksen Courthouse. I can't recommend this strongly enough. I myself go at least twice a week. If I'm going out of town or leaving the city, I'll go every day and just make sure that whoever it is I'm going to go visit is not at risk, and people on the airplane with me. Anybody at all is welcome to be there. You can make an appointment or you can just walk in. They'll accept you even if you just walk in. Again, it's non-invasive, it's saliva, it's not going to hurt. And it's very accurate. You'll get your results. You know, they'll tell you 24 to 48 hours, and that's what we promise. But I will tell you from personal experience, it's often less than 24 hours before you get your results. The test site is open Monday through Friday from 9 to 4 p.m. I think they're closed this Friday for the holiday, but otherwise you can walk on in there. We've administered more than 5,000 tests at that site. And as more of us travel and meet people in person, these tests are really critical. I invite all of you to take advantage. Let me talk finally about some matters of court security. In addition to being able to welcome new citizens at citizenship ceremonies last month, I was pleased to preside over the swearing in of our new United States Marshal, LaDon Reynolds. And did I see him? Yeah, there he is. And Marshal Reynolds, could I ask you to stand up, please? Marshal Reynolds comes to us with significant law enforcement experience. He began his career as a patrol officer with the Oak Park Police Department. Little known fact, one of his fellow officers was John Ness, our judge, who's with us today. And so the two of them have known each other for a long time. Mr. Reynolds rose through the ranks, began as a patrol officer, most recently served as Oak Park's chief of police since 2019. And only days after his retirement, got the call from Washington that he'd been confirmed and came right on over to get sworn in, which made us very happy. We have waited 4 years for a United States Marshal's appointment, and we could not be more pleased by the selection that President Biden made. He's going to be a great, great contributor to our court security. We're glad he's joined our district, as security continues to be an area of real concern for our court. Earlier this year, Congress approved funding for a project to significantly improve the security surrounding the Dirksen Courthouse. Just feet from the courthouse, 4 federally owned and abandoned buildings located at 202 to 220 South State Street present significant security concerns for us. They threaten the safety of the courthouse and that of the more than 70 judges, 1,200 employees, and thousands of members of the public who visit the Dirksen Courthouse every week to serve on our juries, to be sworn in as new citizens, and to conduct business in the courthouse. You likely do not recall, but we in the court certainly do, that in 2004, Gail Nettles was indicted and ultimately convicted of a plot to drive a truck bomb into the Dirksen Courthouse. Recall that this was relatively soon after the tragedy in Oklahoma City. In the wake of this episode in 2005, Congress appropriated funds for purchase of the State Street properties by the General Services Administration for the specific purpose of protecting the courthouse by creating a security buffer. and to set aside property providing what was expected to be a need for additional federal office space in this location. In fact, GSA's need for tenants' office space has declined, just as the need for office space in many arenas has declined. But the need for a security buffer has definitely increased since 2005. The buildings are currently vacant. They are in very serious disrepair. Congress recently approved a plan to demolish them and appropriately secure and landscape the areas surrounding the courthouse will finally fulfill the original intention of that 2005 purchase. I need to acknowledge that demolition of an older structure is definitely a loss, and we are sensitive to the legitimate concerns of our local preservationists who've spoken out against this plan. As an aside, let me point out that the court itself, our court itself, lost an architectural treasure when the Cobb's Courthouse, which stood on what is now the Post Office Plaza, was torn down. We honor that courthouse in our court's history museum. Here's a photo you'll see here of the front door of our history museum. It's on the 21st floor. If you haven't had a chance to, stop up on 21 any day of the week. It's open, it's free, you can walk in. It's not large, but it will give you a chance to see some photographs of that building, and you'll sense too what I sensed about the loss of the design that was there. That said, it was a building that had become very unsafe. It wasn't a place you could bring jurors. It wasn't a place you could bring litigants and expect them to safely and fairly conduct justice. That was the reason for the new building, and that's what happened. In an ideal world, we would never have to lose a building like that, but it happened. And I want to show you a relic from that building. That building, it contained these brass eagles, and this one was donated to us, to the courts. It was donated to our museum. You can't really get a sense of the scale, but it's about maybe 3 feet high. I think it's pretty big. It was donated to us by Scott Lazar, who was, as you know, United States attorney at one point. His father owned that, and he had it in his office for a number of years and donated it to the history museum. Every now and then, if you're kind of a history maven, you'll see one of these for sale, and if you do, please let me know. We'd like to buy it. In any case, you could see that. You can see that eagle, and you can see other parts of the court's history if you stop in whenever you want to. So yeah, we do care about history and preservation, but we think it's important to recognize what we gained by the plan that we have for the demolition of those buildings. The two buildings stand just feet from the courthouse, and I mean literally feet. It houses not only with the courthouse, as you know, houses not only the district and bankruptcy courts, but also the United States Attorney's Office, United States Court of Appeals for the Seventh Circuit, several additional federal government offices. For years, taxpayers have been bearing the cost of maintaining the crumbling facades of those structures. If you walk outside, you'll see that they're protected. And the reason they're protected is that the terracotta is so loose that it can fall and strike somebody on the head. That's the condition these buildings are in. I am sure that many of you, not all, but many of you are proud to practice law in the Dirksen Courthouse. Yes, it's a building, it's a black and glass and steel building, and perhaps looks to you like other office buildings. Certainly it did to me at first. But I need to let you know that it's the only courthouse Mies van der Rohe ever built. It's a building of remarkable elegance and world-renowned architectural significance. The redevelopment project that we've proposed will fortify security surrounding the courthouse. It will demolish dilapidated structures. It will create a plaza between the courthouse and State Street. And we hope it will restore Mies van der Rohe's vision for the Chicago Federal Center complex, a vision of cubic simplicity, exposed structural steel, and elegant open proportion. I want to assure those of you who see this as a loss that we are open to preserving portions of the facade if we can to display in some fashion if that's possible. I also want to assure you that contrary to what the repeated statements in the media, there is no plan to leave an open pile of rubble or gravel pit on State Street. This is, for whatever reason, has wound its way into the newspaper. It just isn't true. The funding that's been authorized allows for paving and landscaping the area for open green space. And I believe and hope that that would enable us to reorient the entrance of our courthouse to the east side of the building as envisioned by the architect in the first place. And I also believe it will bring very desirable foot traffic to a very quiet segment of State Street. Our hope is that this security project will enhance the dignity of the neighborhood, beautify Chicago's iconic State Street corridor, and the Chicago Federal Center complex, and preserve public safety. Friends, we're living in a very challenging time. Global pandemic, deep political divisions, increased violence, and fears about our future, the future of our nation and the globe that seem intractable. Judges and lawyers alone can't solve these problems, but there has never been a time when our profession is as crucial as it is now. Our courthouse, our judicial system, we are the site and symbol of the rule of law, a guiding principle in this democracy. We judges do our best to make hard decisions, and we take our role seriously, but judges never do anything completely on their own. That's why lawyers are so important. Lawyers, you lawyers and your clients are agents for change. Lawyers can lift the curtain to expose corruption, challenge wrongdoing, organize against injustice, advocate for reforms, and speak up for the voiceless. Martin Luther King Jr. famously reminded us that the arc of the moral universe is long, but it bends toward justice. We in the legal system, all of us here, are afforded great privilege, but also tremendous responsibility because we have the tools and resources to bend the arc and make our district and nation better, stronger, and more just. Thank you for participating with the court in that effort. A few minutes, if you have questions, I will try to answer them. Yes, Mr. Rothschild.
Plans for the new plaza, because of the security concern, will that plaza be closed off to the public, or will it be accessible?
No, it will not be closed to the public. In fact, what our hope is that it will be the entrance to the courthouse. In an ideal world, we'll be able to put our security apparatus at that portion of the entrance. We would love, Tom Rutan and I would love to open the atrium, not the atrium, the lobby for things like naturalization ceremonies, for, concerts, for lectures. We would love to use that space. And that would require, obviously, moving our security apparatus outside of the jumble that's in there right now. I would expect that we will probably have those stanchions or the concrete stands that surround the building so that you couldn't drive a truck in, or you couldn't drive one in easily, at least. But no, we very much expect the public will use that space. We'll walk in there. I think there'll be benches. I think there'll be places to sit, perhaps to eat. And that's why I personally think, and I made this pitch. I personally think it would be good for State Street, because we have, even during the pandemic, we had hundreds, sometimes thousands of people in the building. Our building is always open. It's always active. So it really is a way of bringing foot traffic to State Street. People will have to come there for jury service. They're going to come for naturalization ceremonies. You lawyers are going to come when we make you come to court. You'll be there. Yes.
One question regarding the affiliate disclosure. So one question that's come up is some information being requested about affiliates. The companies and the parties to the case may not possess the information to disclose affiliate information. Is there going to be maybe some guidance that comes out in relation to that, or some consideration about changing some way to reflect that reality?
We would give you time to find out. You'd have to do some investigation. Obviously, lawyers don't always know who owns their clients, but it would be the incumbent on the lawyers to find out. I realize that this is not going to be easy. The idea here is that no judge should be making a decision in which that judge's financial interest could be affected by the outcome. It makes perfect sense. It also makes perfect sense that there could not be any genuine reason for concern about a judge's action in ruling on a case in which the judge had no idea that some affiliate was within that judge's portfolio. So it really becomes almost an artificial investigation that has to happen. But we do need the lawyers to be our first protection against the possibility of stepping over the line. And the only way we can find out, we can't investigate on our own. The only way we can find it is by asking lawyers to communicate with their clients about the ownership, structure. It is impossible for us to require you to provide information that you don't know and can't know. I recognize that. I recognize this is going to be complicated and difficult. Yes.
You mentioned that the bankruptcy court has changed their local rules that's a motion hearings in person video. Is there any way to do that?
Already we're using video conferencing equipment for a number of hearings. This has become necessary, not so much because we like it, but because we don't have courtroom space. So the only way to have, if you want to have a live status conference or a live settlement conference, or if you want to see faces, you have to pretty much have to do that on screens. I don't envision us ever using the hybrid process for a trial. I'm talking only about jury trials right now. We already have used a hybrid process for some bench trials. And for those of you who are struggling with getting dates for trials, let me assure you it's easier if you're willing to try a case to the bench. And I got to tell you, 5 years ago, if somebody would ask me, would you ever push a bench trial? I would say, definitely not. Because I like it when the jurors have to make the hard decision. But things are different. If you want to get into the courtroom and courthouse and you want space, a bench trial is going to get you there quickly. So in that respect, I do expect we'll use more technology to enable people, either an individual witness or several witnesses or oral argument, to do some of that by way of video. So yeah, I do think that will happen. By the way, you probably know this, we don't use Zoom in our court. I think the bankruptcy court does. Our district court uses, right now we're using Teams and we use WebEx. Those are the platforms that we use. These platforms don't always work perfectly. I know what it's like to lose a connection and that awkward feeling, or the camera's sideways or something. I mean, those things happen. It's better than not being able to push things forward at all. Let me share with you my own concern about doing everything on a screen. And I know the convenience factor is out there. I'm not naive about the fact that clients have difficulty getting downtown. Your colleagues may be in other cities. It may just be that you yourself are in a far-flung suburb, and to come downtown for 10 minutes just makes no sense. I get all that, and I realize that we really do need to think seriously about using technology to enable participation. My concern is this, and some of you probably heard me say this: when you walk into a courtroom, you know where you are. Just like when you walk into a place of worship, you know where you are. You walk into a grocery store, you know where you are. You walk into an elementary school, you know where you are, by the way things look. And in our courtrooms, we have a very formal look. We have a bench where somebody's sitting up high. We have pews on either side. We have microphones. We have a jury box. We have a well. There's a sense of dignity and calm and respect that I think we convey just by those physical surroundings. Can we do that on the screen? Yeah, we can. It's just much more of a challenge because we don't convey those things just silently by the way everything appears. Judges are now not elevated. They're not necessarily any more important on a screen than anybody else. There's a sense of casualness sometimes that you see on a screen that can be good. I'm not suggesting it's always important to be so formal, but I do worry because I know that people who have their cases in court clients are often, this is their one time they'll ever have any contact with the judicial system. And if they have the perception that we don't take them seriously, or that the whole situation is sort of casual or bureaucratic, I don't know that that's a message we necessarily want to send. That said, I know that my colleagues are willing, just as I am, to explore the various ways that technology can help us make the judicial system work. Any other questions? Okay, silence falls over the crowd. Well, thank you. It's I do have a prediction for all of you. We often ask each other, how long is this going to go on? I'm pretty sure that the pandemic is going to be over the day I'm done being.
Just want to thank you all for coming in, and we're so grateful to Judge Pallmeyer for your keen insight and your candor with us about all of the amazing things going on in the Northern District of Illinois. And we want to welcome all the new partners to the court as well, and congratulations to Mr. Oswald, and thank you for very much the support that you've shown him as well. Thank you.